Hello, my name is Dario Romero, and I'm an attorney here at D. Romero Law. Here we practice immigration, accident cases, and criminal cases. So for today's video, we will be talking about the consular process, which is one of the many possible ways for a person to become a resident. So before I go into the flow of how this case works, it's always important to see whether you qualify for this process or a separate process, because people usually confuse different processes together. So this is the long process that takes 2 to 3 years. Para los que están viendo este video, también voy a tener una versión en español que voy a poner el video aquí abajo en los comentarios para que lo puedan seguir. So the first step in this, the consular process, is the I-130. So basically, someone has to petition you. So who can petition for you? That can be a parent, spouse, sibling, or child. And I'll go into a little more detail in just a few moments, but first, the filing fee is $535. That's the government fee, and this application takes about 6 to 12 months in total. So the I-130 is completely separate from anything else, and like I said, a U.S. citizen parent or resident parent, your spouse, whether they're a U.S. citizen or resident, or even a child who is 21 years or older and is a U.S. citizen. A sibling can petition for you, but it goes into different waiting periods. So depending on the relationship of who's petitioning for you, there might be a wait period or there might be a visa immediately available. So for the purpose of this video, I'm not going to go into detail as to the categories and how long the process is, because it also depends on the person's country. So, like I said, the I-130, the government just wants to verify that the relationship is legitimate. So let's say, for example, it's a husband and wife, U.S. citizen husband and petitioning for his wife. The government just wants to verify that it's a legitimate marriage. If they have kids in common, that's proof. Or they live together, utilities together. And it all depends on who's petitioning who. So the evidence might change from person to person. So let's say the I-130 gets approved, it gets transferred over to the National Visa Center. So that department is the one who processes your visa, and if your visa is available, they're the ones that process all the documents and schedule your appointment at the consulate. So here they look at your civil documents, the sponsor, financial documents, and once everything is submitted, the process takes about 30 to 90 days for them to process it. Something very important, and I always tell people, is that you have to keep communication with the National Visa Center. So for example, if 1 year passes and you already have paid the filing fees, they're going to make you pay those filing fees once again. But if 2 years pass and you have not communicated with the National Visa Center, they're going to cancel your I-130 and you're going to have to start all over. So the filing fees, again, they're $120 and $325. Obviously, there's a lot more details that go into this process than this specific process that I'm not going to go over in this video. So, and then this is the most complex part of the case, the waiver, whether or not you're eligible for a waiver, or if so, what is the waiver exactly? So usually the I-601A waiver, this is the new waiver that happened about 4 years ago that allows people to stay in the country while their waiver is pending. Before, people had to leave the country and they'll be outside the country for about 6 to 12 months, year and a half. Now, thanks to the changes, you can stay here in the United States, but you will still have to go to your consulate for the interview, which I'll go into in a little more detail in a few moments. So this is also known as el perdón, or the waiver, and the filing fee is $715. So who needs a waiver? So let's say if you have entered illegally into the country and you only have one illegal entry, you might be a good candidate for the waiver. Here it's a little iffy, because it all depends. We really have to know all your entries and exits and whether they're illegal or not legal, and how long you stayed, because there'll be a situation where you don't need the waiver, or you might need the waiver, or you don't qualify for the waiver. So at the moment, there is no waivers available from children to parents. So only from spouses and from parent to children, but not from children to parents. So your kids cannot petition for you for this waiver. So basically, when you have accumulated a legal presence in the United States, if you leave the country, you're not supposed to come back for 10 years. So that's the purpose of the waiver, to forgive that 10-year punishment and for you to enter back into the United States. So what we have to prove is that the U.S. citizen or resident, parent or spouse, will suffer an extreme hardship in two situations. So one, if that the petitioner stays here in the United States and the immigrant has to leave, or if the petitioner goes with them to their country. So we have to prove that in those both situations that the U.S. citizen or resident will suffer an extreme hardship. So in order for the government to forgive their illegal presence. And this is not a right that someone has, this is more discretionary, so we have to be very persuasive that in those two situations the U.S. citizen or resident will suffer an extreme hardship. So what is an extreme hardship? Well, there's no specific definition. The government just wants to know that that person, the citizen or resident, will suffer an extreme hardship, that they're gonna live a bad life, their economic situation. This is where we look at health, education, economic, family ties, employment, country conditions, and anything that applies in your case. So the evidence in each person's case will differ. So it's important that you get an immigration evaluation to see what evidence currently exists or that we have to produce. So let's say that the waiver gets approved. That takes 6 to 12 months as well. And then the National Visa Center gets all the documents. Then they schedule your interview at the consulate in whichever country you're from. So with your waiver in hand, you go to your consulate, and then you will have to depart the United States. And you will probably be there for about 2 to 4 weeks to say if everything goes smoothly. So you leave the United States in order to get your medical exam, your fingerprints, and the consulate interview. If everything goes as planned, they'll stamp your passport that you're a U.S. resident, and then you'll be able to enter into the United States. And then you just have to pay an additional $220, that's the immigrant fee. And this whole process takes about 2 to 3 years, give or take. It all depends on how quick immigration is processing the applications. And there's a lot of variables that go into each different case. So I give free consultations, and I'll be able to determine whether you qualify for this process or a different process or a combination. And sometimes we just have to get a little strategic. So my information is on the screen. We're open Monday through Friday from 9 to 5:30. I always come in. I'm always happy to give information and see how I can help you. And our phone number is 602-544-0607. Thank you.